How does inheritance work for a minor beneficiary? Have you ever wondered what happens when a minor is named as a beneficiary in an estate plan? It can be a bit tricky, so let's break it down. When a minor, someone under the age of 18 in most places, is set to inherit assets, they cannot receive or manage those assets directly. This is due to their age and the legal limitations that come with it. So, what does that mean for the inheritance? First, if an inheritance is left directly to a minor without any planning, a court usually steps in. The court will appoint a guardian or conservator to manage the assets for the minor until they reach adulthood. This process can be costly and time-consuming, and it may limit how the inheritance is managed. A popular way to handle a minor's inheritance is through a trust. The person creating the estate plan can set up a trust that holds the assets for the minor. A trustee, chosen by the person who created the trust, will manage the assets according to the trust's terms. The trust can specify when and how the minor will receive their inheritance. For example, it can allow distributions at ages like 21 or 25, or even after the minor completes their education. This method provides security and ensures the inheritance is managed wisely until the minor is ready. Another option is to use a custodial account under the Uniform Transfers to Minors Act. In this case, a custodian is appointed to manage the assets for the minor's benefit. Unlike court guardianships, custodial accounts do not need court approval for distributions. The custodian can use the funds for the minor's benefit before they reach the age of majority. Once the minor reaches the specified age, they gain full control of the assets. If the inheritance amount is smaller, often under $100,000, it can be placed in a court registry account managed by the county clerk. This account holds the money without investment, earning little to no interest. The minor can access the funds upon turning 18 by showing identification. However, accessing the funds before turning 18 requires court approval, making this option less flexible. To avoid complications, it is essential to include specific instructions in the will or estate plan about how to manage the inheritance for a minor beneficiary. This could involve naming a trustee, specifying the use of a custodial account, or setting up a minor's trust with clear guidelines on distributions. Proper planning helps prevent delays and ensures the minor's inheritance is handled according to the wishes of the person who created the estate plan. In summary, managing inheritance for a minor beneficiary involves legal arrangements like trusts, custodial accounts, or court-appointed guardianships to protect the minor's interests until they can legally control their assets. Seeking advice from professionals in estate planning can help create the best arrangements for both the testator and the minor.